Kimberly Cookson and Brandon Alexander.
That matter's ready, Your Honor.
Lawrence Glaser, I'm here for the plaintiff and we're ready.
All right, I think it makes sense to start with a motion to dismiss. Mr. Glosser, your motion.
Okay, thank you, Your Honor. As you know, there's two motions today. We're going to talk about the first, the motion to dismiss. The plaintiff's position is straightforward. The court may grant voluntary dismissal under CR 4A2, and the dismissal should be without prejudice. Defendant is not entitled to request global fees, which we'll talk about later. If the court concludes some narrow collateral fee issue survived from May 14th, the issue must be strictly confined to the discrete matter and cannot be turned into an all-case sanction or prevailing party judgment. So the voluntary dismissal should be without prejudice. We acknowledge that this is subject to CR 41A2 because the defendant answered. We don't dispute that. But the defendants are trying to convert that procedural point into a substantive fee entitlement. And that's essential in his briefing.
I've got a question about the idea that the defendant answered. Would take this from 1 to 2 under in CR 41. Because in reading your pleadings, I read some of the cases and I read, seems that parties could be engaged in discovery. There could be motions. Summary judgment seems to be, well, the rule reads it's mandatory if it's done before you rest your case. It seems that that's kind of been interpreted by the courts as not necessarily your case at trial, but it could be a summary judgment motion or other dispositive motion where the court actually gets to the merits of the claim. So I'm not really understanding why this would be permissive as opposed to mandatory by just somebody answering, because I don't see any support for that idea in the briefing or in the record, or I mean in the cases that were cited.
Well, it says when it's mandatory if we move for dismissal before final judgment, and there's been no final judgment in this case, and we haven't ended the case. We've had it ended the case because we're asking it to be voluntarily dismissed.
Maybe my question's not clear. You initially moved to dismiss under 41A1. And it seemed that was significant, whether the court dismisses regarding A1 or A2. A1 is mandatory. It's a matter of right. A2 is reads after the plaintiff rests their opening case. You could move for voluntary dismissal, and then upon good cause shown, the court can order such terms and conditions as the court deems proper, which is where Ms. Winkels is indicating the court has authority under 41 to authorize or order fees. So that seems to me to be sort of a critical question to begin with.
I think
I'd like to hear from both parties regarding that issue.
We did make the motion to 41-2A, A1, the initial motion to dismiss. There was a procedural problem because we inadvertently did not give Ms. Winkels adequate time to respond to the ex parte motion, and that's primarily why we're here today.
All right. Anything else on your motion?
Just, just to put a little background on it, why the plaintiff sought the dismissal. And defendant repeatedly uses the phrase abandonment and compliance, and that's rhetoric, not analysis. What happened was this. At a December hearing, testimony indicated there was a gate that was at least partially on a neighboring property, which raised a joinder issue. At the same time, defendant was pressing a broader CR 19 and a CR 12B7 theory, contending that multiple owners along the Libby Lane route had to be joined. In that posture, plaintiff deferred serving Mr. Hine, who the gate was partially on his property, pending the court's ruling on the broader necessary party issue, so that the amendment joinder could be addressed comprehensively rather than piecemeal. Then on May 14th, after the court granted the joinder motion, plaintiff evaluated the estate. The estate wanted to evaluate whether the estate wanted to expand this case into litigation against all relevant owners along Libby Lane, and made a measured decision that it did not. And that's a legitimate litigation reassessment. It's not bad faith. And Ms. Cookson's declaration really explains it. It places the May 14th decision where it belongs, with the client. Ms. Cookson explains that after the court's joinder ruling, she considered the burden, expense, delay, complexity, expanded multi-party litigation, decided the estate did not want to proceed that way. And that's exactly the sort of practical litigation judgment parties are allowed to make. It became a much more complicated case, which would involve multiple parties, and the estate just made a decision that they did not want to pursue that. Couldn't do that until after the May 14th ruling on the joinder. Defendant says it somehow proves bad faith because dismissal followed the adverse ruling, but parties often reassess after rulings that materially increase the scope and cost of litigation. That's not sanctionable. It's ordinary civil practice.
All right. I guess, Ms. Winkels?
Hold on 1 second, Your Honor. I'm trying to, okay, there we go. Instead of starting, I'll just answer your question. Your Honor, for 3 reasons. And the first is dispositive. First, the plaintiff already conceded it in their July 20th reply at page 2.
No, I understand that, but if
Okay.
if there's not a legal basis for the concession.
Yeah. So second, the vehicle that the plaintiff chooses confirms it. But the fact is that a dismissal under A1 is one of the plaintiff takes as a right by stipulation, by the plaintiff's emotion. That's not what we have here. The plaintiff only asked for it under A2. But the fact is that the posture forecloses A1. The mandatory non-suit under A1B runs only before the plaintiff rests on the conclusion of their opening case. The court's May 14th order dismissing for failure to join the necessary parties, that's where the defendant's fees were reserved. The court will recall the history that
The fees were reserved as to that motion, as I understand the court's ruling.
Yes, the motion for a joinder, and the court stated that if the parties weren't joined, they were going to dismiss. It was our motion to dismiss. And the court stated,
but joinder, as a summary judgment, gets at the substance of the claim. You don't have facts here to move forward. Joinder is almost the opposite in terms of addressing the substantive claim. It's saying we can't address the substantive claim until we have the proper parties before the court.
yes.
So how is that at the conclusion of the plaintiff's case?
Yeah, so I think what we have here is kind of the cart before the horse. So you're absolutely right that answering itself does not convert a non-suit to an A2. It doesn't rest on the defendant answering it. But what we really are looking at is we had 2 motions before the court. One was whether or not the parties needed to be joined. The alternative was a motion to dismiss. That motion to dismiss would have made this an involuntary dismissal. It wouldn't have been the plaintiff resting. That motion's still open. It wasn't decided. The court said that if they did not join the parties under the other motion, that they would dismiss on our motion to dismiss. And it appears I'm frozen, so I'm going to turn my video off. The court stated, because we had the two motions going on at the same time, the defendant did, the motion to join, and then we had a motion to dismiss. The motion to join the parties, that was granted, and if they weren't joined within, I believe it was 60 days or whatever the court gave, then we would be granted our motion to dismiss. Now, our motion to dismiss asked for significant fees, and that would have been involuntary on the part of the plaintiff. That's the difference. So it's absolutely true that that it would have been available for them, A1, if they had been the party to ask for a motion to dismiss prior to mine being heard and decided on. And I think that's what it turns on, is they can't claim that, they can't. It was a dispositive motion. So the May 14th order dismissing the parties for failure to join with the defendant's fees reserved, that is, and then doing the ex parte order, that doesn't renew some motion that they didn't do. The plaintiff can't use it as a right of non-suit to walk away from a dispositive ruling that's already reserved a fee award. And that ruling was, if they don't add these people, then they're going to grant defendant's motion to dismiss. And we ask for fees in that. So I believe Your Honor is right in that answering itself doesn't convert, but I think that it's more important that this is not a non-suit because we had our dispositive motion before the court. And I think the plaintiff's own replying Gutierrez and Escude for the terms and conditions of authority, which are already in the brief, I think those take it to this area where the plaintiff can't just walk it away.
Okay. I think there's the record's a little unclear to me about that hearing, the Joinder hearing.
And that was, not to interrupt you, Your Honor, but that was one of the issues is we were supposed to put an order before the court on presentation. I drafted that order. And then an ex parte order without my knowledge got filed and signed, and we did a motion for reconsideration, and that order, motion for revision, and that order was, sorry, it is reconsideration. That order was vacated because it wasn't properly before the court. We had a presentation set.
No, I understand.
Yeah.
I understand that. I'm looking at the notes from the clerk's notes from May 14th, and I haven't watched the hearing. This was set to address a motion to dismiss and then proceed to summary judgment.
And in that case, they decided to take the joinder and the dismissal first, and then if it was dismissed, obviously not needing the secondary hearing of the MSJ.
Right. So I guess what my point is, it doesn't seem to me that the summary judgment was actually litigated. It seemed that it was more, and maybe I want to make sure that I've got the facts right. But my understanding of the ruling was either you name these parties or the matter will be dismissed because you haven't done that. But if you name the parties, then we'll move on to summary judgment.
I think that's right, but I think the dismissal is our motion to dismiss is a dispositive motion. It ends the matter. It ends the matter, and our request was for fees to end the matter and for prejudice for not joining the parties in this action. So a matter of right under A1, the court doesn't have any discretion. So why can't the plaintiff just take the A1 and dodge the fees? The fact is that the subsection does not matter for fees if this court's already reserved on them. On May 14th, the court granted the motion to dismiss for failure to join the fees and reserved the defendant's fees on that motion.
Okay,
Yeah.
I absolutely agree that the court, in ruling on that motion, awarded fees and had the ability to do that. And any subsequent dismissal order would not, whether that's under A1 or, well, even if it's under A1,
Okay.
it doesn't eliminate those fees, and those fees
Yeah.
are still owing.
And that feeds into the second. A1 is not even available to the plaintiff on this record because the as of right non-suit under A1B runs only before the plaintiff rests at the conclusion of their opening case, trial stage, right? That never arose here. But it also does not lie where a dispositive motion has already been granted against the plaintiff and where the defendant has a pending reserved claim for affirmative relief, which is exactly the posture in this case. So that's why
Are you citing a case? What case are you talking?
yeah, in that case it is, let me file that one. I'll have to look in my, hold on one second. Sorry, it's in my notes and I just said, look at other case.
No, I know there are a lot of cases.
Yeah, there's so many. I have a list of them, but let me just see if I can find it. I made an index, but there are like 100 cases in that index. I'm not sure if it's going to be useful. Okay. Here's one. Okay, so the Washington case that's usually cited is Barrett, oh my gosh, BERITICH v. Starlet. And they already cited that in their briefing. It doesn't cover all of that, but it talks about the affirmative relief path. There's also the Scude v. King Public Hospital and Hawk v. Bronhays, where a fee award is collateral to the merits and the court retains jurisdiction to enter it after voluntary dismissal. That is the one that means the May 14th is extended. And then the pending affirmative relief point is traces to the rule that the right to non-suit is not absolute from Beretich. Because, and also Escude and Hawk hold that the reserve fee is collateral and survives any dismissal. You have to read them all together in order to see that if you have a pending affirmative relief, that if you have a pending action where you're requesting affirmative relief, even if it can be dismissed, it's not dismissed under non-suit. You don't get just to walk away. And I can try to pinpoint the actual case I got, but I might need a couple of minutes for that.
Yeah.
Okay, give me 1 second.
May I add something on at this point?
Ms. Winkels, are you done?
Just on the question you asked, I didn't argue any of the motion for dismissal. I'm not sure if you even need me to, or.
Mr. Glaser, go ahead.
Well, first of all, my recollection of the May 14th hearing was that she requested fees, and she initially just put in fees for the motion. But the real issue in this case is there is no basis for a fee award. There's no basis under statute. There's no basis under
Okay,
contract.
regarding the May 14th ruling, that that ruling's been made, and once there's an order entered on that case, or on that hearing, or, you know, perhaps even a presentation, you can make that argument to the court who ordered fees.
Your Honor, there was a hearing on presentation scheduled, and we were ready to respond to those things. But Ms. Winkels asked to be continued because she was on her way to the airport. So there really was no hearing on presentation.
I understand, but I'm not gonna rule on that because it's Judge Basher already has. And that order, there needs to be an order that comes out of that hearing. I know he's waiting for it. So that issue I'm not going to address. I'm just trying to figure out
So
still the answer to my initial question. But
a couple of things, Your Honor. I just looked back at my original motion for voluntary dismissal, and all we cited was CR 41. We didn't say 1 or 2. We just cited under CR 41. When Ms. Winkels made her request for fees and put her fee declaration, she never did indicate under what provision she's entitled to the fees. And there is none in this type of case.
okay, before we get into fees, Ms. Winkels, I think, had more on the motion to dismiss, or at least I want to give her a chance
Yes,
All
to
right.
address that.
yes, Your Honor. Really, the court already granted this motion. They granted my motion, and they did that on the record in the court, and they stated that if you did not join the parties at this time, that my motion to dismiss would be granted. My motion to dismiss asked for significant fees. It didn't ask for fees just on that motion. In fact, we put an affidavit of attorney fees for everything. In that case, we asked for all of it. What the court reserved on the amount and said that the motion to join the necessary parties fees were going to be given, because he granted that, and alternatively, if they weren't joined, the motion to dismiss would be granted. So he reserved on the amount of awards for the motion to join parties, and he reserved on whether or not we were actually going to dismiss the action, and reserved on the full fees. That's how it went. The court granted it and ordered the joinder, and then said again, if the joinder is not done, then we will dismiss. The plaintiff, the fact is that motion, my original motion to dismiss, was necessary. It wasn't a technicality. It went to the heart of why the case was misconceived. It's still open. It's still open. My motion to dismiss is still open. I don't need to go through all of the reasons why it's open, but it was clear on the face of the entire lawsuit that it never should have been filed. And no matter how many times I told Mr. Glaser, I gave Mr. Glaser the available public records. We came before the court, and Mr. Glaser would lose an action and come back and do the same action again and lose that one and come back and do it again. And the reason that was happening is because the public record was very, very clear. CR 19A says, is the joinder, they had to be added. You have to do a reasonable pre-file inquiry, which was also not done. Then we go to the entitlement that the court reserved and the amount. On the amount of the joinder, our $7,637 is appropriate for that order and that motion to join. However, it was granted in an alternative, either join or we're going to grant the motion to dismiss. So that should be granted on the motion to join, but the fact is they didn't join. Our motion to dismiss is therefore still before the court, and that is a dispositive motion. A motion to dismiss ends a case. It is a dispositive motion. It can be appealed, unlike a non-dispositive motion. And that is what takes this out of the A1, because that was not granted and it was not denied. It was essentially, if A doesn't happen, then we are going to grant it. It was contingent on whether or not the parties were joined, and they were not. I'm still trying to find the case law for you on having an open, where there is an affirmative, a claim for affirmative relief still there.
No, I'm fine with that case law.
Okay, so that the fact is that our motion to dismiss is already there and we asked for attorney fees. It was a dispositive motion. We all filed the documents. Essentially on that dispositive motion, we all rested. We had the hearing, we rested, and the court ordered 60 days, join, or I dismiss on Ms. Winkels' order. The order was orally given, but was not put down, but an oral order is still an order of the court. And the fact is that you don't get to all of the case statutes. This is, let me just start with a number, 1,664. That's how many pages have been filed in this case. There's been 170 docket entries, and we've been in front of this court no less than 7 times. The fact is this is not a litigation where the plaintiff can just walk away without anything happening to them. The question is, who pays for a lawsuit that should never have existed, which is why we did our motion to dismiss. It shouldn't be my client. We have made Mr. Glaser and his client more than aware that there is no law and no fact. Additionally, their argument, and we can go to that, their argument is based on the real estate contract is part of their argument, and that gives an award for fees as well. So we have, we have a bunch of things going here, but A1 doesn't work because we still have an open dispositive motion before the court. It rested. That's why we can't go that way. That's why Mr. Glaser didn't plead that in his pleadings. That's essentially where we are. The motion to dismiss is the clearest example that's running through the entire case. Our basis for that was no reasonable pre-filing inquiry, the wrong parties, the wrong theory of public record, and it drove him to answer again and again. CR 41A2, court keeps inherent authority. And if the court is ready, I can turn to that and we can move to fees. But the fact is that you don't get to just swoop in and put an order in dismissing. And this is the real question of how do we know that this is a dispositive motion? We know that because Mr. Glaser, when he filed the order that got rescinded, that got vacated, he didn't file a motion with it. He filed that order to the court ex parte on my motion to dismiss. So he filed that order against my motion to dismiss. Otherwise, he would have had to set this for hearing, and he didn't. He filed an ex parte order alone, and it was signed mistakenly thinking that there was some sort of agreement on my motion to dismiss. The only motion before the court that time was my dispositive motion. That's why A1 does not work. It has to be, this has to be under A2.
May I respond, Your Honor?
Just 1 second, and then yes, but just give me a minute here.
Just to respond to a few things. This was a legitimate controversy on the CR19. Ms. Winkels has a position, we had a position, and we legitimately argued it. To say that I was somehow throwing motions and doing other things isn't true. When the mass of paperwork was presented by Ms. Winkels, some 160 pages with a motion, and I think even the commissioner was a little disturbed by that one on that day. But nevertheless, after May 14th, the landscape of the case changed. We came into the case seeking access and seeking the ability to access the estate's property, which was totally cut off after this. We never made an action or suit on the contract. We never brought a motion on the contract. Even on in any of her pleadings, and she's never cited the independent source for fees. And even if I accepted the fact that they spent that much on the case, there's no independent source to entitle the fees. And I think that's the essence of this case. I mean, we follow the American rule here that each party pays its own fees, unless there's something by statute or by contract, and neither of those are here. So, yeah, we can argue about the timing of the motion, and I do acknowledge that we did file the motion prematurely, but nevertheless, our right to the voluntary dismissal still exists. And as I say, it happens all the time in litigation where parties reevaluate when the landscape changes, and that's exactly what happened here. My client, the plaintiff, we anticipated litigating against one individual, Mr. Alexander. Then we find out that he put a gate on someone else's property, at least partially. And so we said, well, we're gonna have to join that party. And then the motions to the CR-19 motion to join all these necessary parties came up. That was litigated, and that was not decided until May 14th. May 14th, the court made a decision, and I'm not arguing with the court's decision, but my client made a rational decision saying, we didn't come into this thing wanting to have a lawsuit with 20 people. And she made the decision that at that point, there was no basis to go on with the litigation. I didn't understand the May 14th hearing to be one that would award any fees, other than there was a discrete fee agreement that was never cited the entitlement for it. The court said, I'm going to give you fees, but there was not an entitlement, and her initial fee doc was only about $7,000. And somehow it got bootstrapped into $62,000. And again, without any entitlement. We can argue all these things that happened during the case, but I have yet to see the contractual provision, and I yet to see the statutory provision that entitles them to fees.
Ms. Winkels, anything else?
Yes, Your Honor, I'm going to try my video. Cannot start video. Okay. I'll go with that. Your Honor, if we're just looking at the motion to dismiss, again, my motion is before the court. My motion is a dispositive motion to dismiss. The court clearly stated that they had 60 days to join the necessary parties, and if they didn't, they would dismiss on my grounds. They failed to do that. That would have been the way forward. We were granted reserved fees on that motion to join parties. We waited to see if he would join them to see what the fees were for that motion itself. The reservation of fees on the motion to dismiss are still out there because that motion was contingent on them joining the parties or not. They chose not to, which means it was going to be dismissed, which is why Mr. Glaser filed an ex parte order to dismiss, which was signed and then vacated. The second thing is that Mr. Glaser cited A2 in his own request. The court cannot supersede his request by planting a different request to modify in there. And it is correct under if A1 is correct, then A2 is also correct. There is, if A1 is correct, you can use A2. If you use A2, you cannot go back up to A1. But if A1 is available, A2 is always available. The fact is he requested it he elected A2 himself. They did not file a notice of non-suit as of right. They filed a motion asking the court to enter an order of dismissal. The plaintiff also wrote in that this is a motion under CR 41A2, not a dismissal as a matter of right. They chose the permissive vehicle and conceded to it in writing. The court can hold them to that. Second, independent of the label, the matter of right non-suit cannot be used to defeat a defendant's pending right of affirmative relief and the pending motion to dismiss. It doesn't erase what's already been granted, and it doesn't erase anything that's contingent on what they were supposed to do. It changes nothing on the fees. The fee award is collateral to the merits and survives the voluntary dismissal under the Scude and Hawk anyway. It's not an escape hatch. Whether the fee flows from A2's terms and conditions, power, or from the court's retained jurisdiction and inherent authority, either way, the court can award fees in this case. And the fact is that the case in this is, so they can award based on those 2 points, and they need to award based on those 2 points. The fact is that every document I submitted to this court, every single reason he lost on every motion was because every single document is available for public record. You can download them. I didn't even go and ask for them. I got online and I downloaded them. They showed that my client faces an easement system that has been in place since the 1970s, all the way up through the 2000s, that there are properties on that easement, Libby Lane corridor, there are properties on that road. So asking for the right to enter, and all of his claims are based on going through my client's property and jumping on to an easement. That is settled law. There is no question of fact or law that overcomes that settled question. Secondly, there's no unity of title here at any time. These are questions of fact that were determined by the deed documents themselves, by the easement documents themselves. These are nothing that can be litigated or changed. They are just how they are. Now, interestingly enough, the only thing that Mr. Glaser could have chose to sue on and possibly have a chance that might be based in fact, and I'm not going to say if it is or not, would be a private way of necessity where the attorney fees for the other side have to be completely paid and the use of that has to be completely paid. That's the only one that would have worked here because it doesn't require unity of title, and it's almost a condemnation action. It requires necessity. Everything else in here is out of place. The fact is I've already proved this. I told this back in December. We went through the court and the court stated, no, I'm not going to make that happen. That's not a party. You need to join the parties. He brought it back, joining only one of them. It was defeated again. So the December 10th ruling, he says the gate location was only tentative. The point is that any single ruling was final. The plaintiff had notice of the recorded facts from the outset, and the court on 1210 and the verified discovery on 323, the 212-page 414 document, yet he pressed on anyway. Notice plus persistence is a bad faith showing. The second one is what the plaintiff should and should not have done. And again, they give only one mechanism here where forcing access across a neighbor's land where no easement exists is the private way of necessity under RCW 8.24.010, the condemnation action I told about. They never pled that. And it's not in there. CR 19, the failure to join. This court ruled on May 14th of that. It shows that they continued to ignore from the start what we had been saying, what the facts of the case were. This is a pattern of excess in this case, which is totally unfair. File, lose, refile. Who made the paper here? The volume in this litigation is extraordinary. There have been 1,664 pages filed in this across 170 dockets. Of that, we filed 656 pages of exhibits at the beginning showing exactly what we said to make the parties necessary to join, that you must sue everybody if you want an easement. My client is one man who has now borne the burden of them failing to look at the public record. That is patently unfair. Instead, we have, it was denied. Their preliminary injunction was denied on December 10th. They refiled the same request as a renewed motion for preliminary injunction at CP 43, this time propped up by an out-of-state engineer who never inspected a bridge, which it doesn't matter anyway for this case. That would have been a private way of necessity under RCW 8. We then had that, they obtained a voluntary dismissal order on June 1st. The court voided it because it was never heard. The plaintiff simply refiled it today as a motion for voluntary dismissal today. The plaintiff has filed 11 separate declarations of Ms. Cookson, including a second supplemental and a notice of errata correcting an earlier one, and 8 declarations of counsel. Twice plaintiff brought a motion, lost it, had it undone, and brought it again. Every filing landed on my desk, and I had to answer all of them. If we look at, there were 356 pages of documents drafted by my office. There were 396 drafted by plaintiff's office. That is not normal litigation. We put nearly 700 of recorded documents, publicly available documents, in front of the court for one reason, because they did not appear to be reading what we were giving them, what was out there. So what the cases say and why. Southwest Suburban Sewer and Fish says that recognizes procedural bad faith, vexatious, repetitive, cost multiplying conduct as a basis for fees under the court's inherent authority. Applies directly to file, lose, refile pattern and 11 duplicative declarations. Plaintiff calls these refilings a right to renew or ordinary practice, and that is not the case. It's not whether plaintiff could file. It's that each successive filing multiplied the cost of defending a case that it should never have been brought in the first place. And then the court can award fees today. There are 3 independent sources. First, the court plainly has jurisdiction to decide fees notwithstanding a dismissal. A fee motion is collateral. The court's July 6th order at CP 144 expressly told us to bring it on a properly noted motion after hearing. That's this motion. The fees rest on 3 independent grounds. First, CR 41A2, because Alexander answered long ago and put in a dispositive motion. Plaintiff cannot dismiss except on the court's terms upon such terms and conditions as the court deems proper. And that discretion includes conditioning dismissal on payment of fees. And then Gutierrez draws the controlling line, which is withdrawal for reasons unrelated to the merits is ordinary autonomy, but withdraw after an adverse ruling where the defendant spent heavily to win it may be conditioned on payment. Again, that is the most important thing from Gutierrez, that it says that a withdrawal for reasons unrelated to the merits is ordinary autonomy, but withdraw after an adverse ruling where the defendant spent heavily to win it may be conditioned on payment. And Ms. Cookson concedes the exact trigger. She said she chose to dismiss after the court's May 14th joinder ruling. That's her declaration at line 3 to 7. Second, the court's inherent authority to sanction bad faith litigation, substantive procedural under Fish. And third, in the alternative, RCW 4.84.330. It should dismiss it with prejudice. And I have lots of cases that I've cited. I'm not sure if Your Honor wants to note those or wants to have those, but when they're saying they did not sue on the real estate contract, that's the 4.84330 thread, I'd like you to look at the plaintiff's own complaint where it's pled prominently on page 2. In the party's introductory allegations, it states defendant Brandon Alexander is the vendee, and it goes on to state that the contract was drafted by his attorney. Page 3 alleges the contract did not address continued access to the Turbot property, and there is further reference to the contract on page 5 with the claims. It's not a stray mention. Plaintiff built its access theory on the real estate contract, which is exactly why the action is on a contract for RCW 4.84.330 purposes. They stated in that complaint that it was a mix-up, essentially, that it wasn't in there. And that was why they tried to subpoena the former attorney who wrote the real estate contract. A lot of the discovery was aimed at that, which shows that it is a complaint and it is litigation on the contract. So fees, those are the 3 things of fees. In Gutierrez, we have Southwest Suburban Sewer District and Fish, inherent authority to award fees for substantive and procedural bad faith, the independent equitable grounds the American rule requires. We have Wachovia and Kraft. A dismissal without prejudice is no final judgment and creates no prevailing parties, hence the request to dismiss with prejudice here. RCW 4.84.330 and also Alahari and v. Carter Subaru, a bilateral contractual fee clause is enforced for the party in whose favor final judgment is entered and with prejudice dismissal qualifies. That is what they are trying to get out of, and that would be $63,000 thrown away. That is not fair. We have a motion to dismiss before this court. And Condon, the American rule, fee requires contract statute or equity. Fish gives your honor equity, and RCW 4.84.330 gives your honor contractual ability to do that. The fact is that plaintiff is trying to invoke that there's no prevailing party, and that only supports entering a with prejudice judgment that cures that. And if you look at 41D, CR 41D, it only reaches taxable costs, and later refiled cases, it does nothing for the fees already incurred here. Every single dollar of this case was to try to, there was a flurry of paper. For once in my life, I realized what it's like on the other side to get buried under paperwork by another attorney. Every time I closed my eyes, there was another motion. I would start drafting a motion and more pleadings would go in. It wasn't, even when Mr. Glaser was not the moving party on a motion, he still filed two separate pleadings. He filed his reply and then his reply on every single time. That's not even allowed. I objected to all of that.
I'm sorry, I'm gonna reject. She's telling you things that aren't true.
It's, if you look
I'm
at the
sorry,
case
Your Honor.
today, and if you look at
Alright.
the case last,
Wait
if
a
you look
minute.
at the last motion,
It happened one time.
and this motion this time too.
There was no sue.
Okay, now, between the two of you, stop.
Your Honor, I didn't think we were here to try the whole case today, but it sounds like Ms. Winkle wants to try the entire case. I think maybe we filed 3 or 4 motions in the entire case. Once we had to deal with the CR 19, we opposed that. We thought we had good grounds to oppose that, and we lost. Ms. Winkle's talked about a lot of things today. She's never told us one thing, though. She never said, where's the entitlement to get the fees? And she quoted the case that cites the American rule. So even if she was the prevailing party, and I'm not saying that she was, there's no basis for a fee. There's no contract and there's no statute. Now, she talks about the contract. If we'd have sued on the contract for breach of contract, if we'd have sued for rescission, if we had sued for anything that touches the contract, she might have an argument there. But that's not what we did. We sued only for continued access because essentially the decedent had cut off only access to his own property. And there was like 20 years of use prior to that, including use of the so-called easement road. And Fish doesn't say what she says it is. Fish is a narrow fee entitlement case and not a broad sanctions case. And it held that they brought that one under 7.28083, which is an adverse possession case. And so that what they were trying to do was support an easement by prescription. And the court said, no, you can't bootstrap that onto a case that authorizes fees only in an adverse possession case. And I don't want to take the court's time with relitigating the whole case, but I would like to hear, because I've never heard it and I've never seen it in motions, what is the entitlement to get the fees?
Your Honor, just briefly, the entitlement are 3 separate entitlements, which is what I said. It rests on first.
And I heard some,
I can actually.
I've heard them.
Okay. The Hawks and Branhes 97 Win App 77 1999. Whether a voluntary non-suit warrants fees is committed to the trial judge's discretion. That in itself gives Your Honor the discretion. And also in RE detention of JR 80 Win App 947 1996 and Port Angeles v. CMC Real Estate 114 Win App 2D 670 in 1990, broad discretion to impose conditions, including financial conditions on relief. And it supports dismissal on payment. And then finally, Your Honor, there were not a few motions Mr. Glaser filed 10 motions: motion for preliminary injunction, motion for temporary restraining order, motion for leave to amend complaint to join additional defendant, renewed motion for preliminary injunction, motion to compel discovery and for sanctions, motion to strike portions of Winkels' declaration, motion to strike portions of Alexander, motion for voluntary dismissal with prejudice, motion for leave to file a server reply, renewed motion for dismissal without prejudice.
Your Honor, the cases that you hear where the court has some discretion, the one that comes in mind is now the adverse possession. And the court said, the case says the court may award fees, has the discretion to award fees, but that's coming out of a statute. And there's no statute on CR 19, which she won, or the fact that she may have prevailed and convinced the court that we had to join, I don't know, all the parties down the road. So at that point, it was a rational decision not to proceed with the case. And like I say, I still haven't heard where the entitlement comes from.
And there's,
I understand that point.
there is another case, Your Honor, Gutierrez and ICICLE Seafoods, 198 WinApp 549, 2017. Withdrawal after an adverse ruling with fees already incurred may be conditioned on payment.
All right, and Gutierrez is a summary judgment case, and where the court actually got to the merits, which is what I saw with a lot of the cases.
And isn't that what the motion to dismiss was that we had, that the
The
defendant?
motion to dismiss that you made was a joinder motion with,
Well, there was a motion to
dis-
join. Oh, sorry.
there was a motion to dismiss for failure to join parties. And the court conditionally granted that unless the plaintiff joined the parties within, I think, 60 days. And in the meantime, the plaintiff filed a motion to dismiss their own suit.
Doesn't it become dispositive when they don't join the parties at that point? And we did ask for our full fees in that.
Dispositive, I don't think is the analysis. I think is that what's the analysis is did the court get to the merits of the claim?
And
Because
didn't they get-
in
No.
the cases that I saw where the court said dismissal, mandatory dismissal wasn't allowed, or even permissive dismissal, was where, like in mandatory arbitration, where a case had gone to arbitration, an arbitrator ruled, and then there was a de novo review to the superior court. The court said you can't, there's already been a ruling on the merits. You can't dismiss. A voluntary dismissal will not, is not available to the plaintiff at that point.
And isn't this the same? Didn't, Your Honor, didn't the court get to the merits of the case against my client when they determined, based on all the public records that had to be read? We're talking about 656 pages of publicly filed
You'd have
documents.
to ask Judge Basher. Because it seems like, no, he didn't. It didn't seem like he got to the merits. He said, my understanding of that ruling is we got parties we need to be involved in this case in order to get to the merits. And they're not here. So if they don't get here, we're going to dismiss because we can't get to the merits.
And that, I think, says if there is, you would have to get to the merits about my client, though, to reach that conclusion, because if there's no capability of having an easement against my client without a bunch of other people being there, and those people aren't added, then you've answered your question on the merits of this case, then you can't bring a suit against my client. Then the merits have been determined, because you have to go through that, number one, to find out who would need to be added, but you also find out at that time that it can't be brought against my client as a sole man, and that is a question of the merits. Can action be brought against him on his own for an easement that he doesn't have any ability to grant? And the answer to that is yes, that is a question on the merits themselves of the case against my client.
Well, we had a number of theories on why we should be able to have access across Mr. Alexander's property. And we never got to those merits at all. We never did, because we got all the confusion about the CR-19 and everything else. And the gravamen of our case was we need to get to our property, which is now landlocked and cut off. And there was no ruling on those merits. And there's no final ruling in this case. And again, I keep asking, where's the entitlement?
Yeah, I understand that. Yeah. Okay, I'm gonna take it under advisement. I'll get a decision out, written decision, as soon as I can. Thank you.
Thank you, Your Honor.
Thank you for your patience and attention.